the word deposit or the word retainer? Which one should you use in your client contract and which one should you avoid? The answer is going to surprise you on today's episode.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey there, welcome back to the podcast. Thank you so much for listening. I really super duper appreciate it. If you've been enjoying the content of the episodes, it would be super great if you could subscribe wherever you're getting this podcast from. And particularly if you watch it on YouTube, if you could subscribe to the YouTube channel, that would be fantastic. I cannot do a YouTube live video from a mobile device until I get 1,000 subscribers. And that's kind of my goal. I would really love to do YouTube live on the go from my mobile phone. But at any rate, if you could do that, that'd be fantastic. That is my one ask for this episode. Also, if you have ideas for content, please let me know. Shoot me an email, rob@weddingindustrylaw.com. Hit me up on Instagram. You leave a YouTube comment. This episode is the result of a YouTube comment. Trisha Bennett asked what the difference is between retainer and deposit. And so in honor of that, I really appreciate that. I'm going to talk about that this episode. So, all right. So you're a wedding professional and you have a contract that you have your client sign. So most often you are going to desire that there is a certain amount of money that you're going to retain, that you're going to keep if the event is canceled for a particular reason. Typically the reasons are the clients get cold feet. They just don't like each other anymore. Some reason that the event is canceled that is within the control of the client. So you've got, likely in your contract, you have a clause that you keep a certain amount of money in the event that the client cancels the event. Some of you call that a retainer. Some of you call it deposit. Sometimes it's payment, installment, whatever. The question of the day is there a particular term that it should be called that is better than others? Is deposit better than retainer? Is retainer better than deposit? The short answer is it's going to depend on your jurisdiction, but very, very likely it actually doesn't matter at all. The most important thing that you can do if you want to retain money for any reason in that contract is to spell out the specific terms of when that money goes back or doesn't go back and why. So for example, you could say something like X percentage is being kept if the client cancels because, they don't want to get married anymore. This is just a ridiculous example, but that would be what it is. So that you're explaining the triggering event. That's the first part of what's important, what the actual important part is, rather than what you're calling it. The second part is explaining to the client in the contract why that money doesn't go back. So you're explaining to the client in the contract, we do things ahead of time. It's not like we get a vacation because you've canceled the event. In other words, it's not like I'm jumping up and down because I don't have to work. I mean, we're not, this isn't a shift at Taco Bell. We're talking about we're going to be out profit, this type of thing. So we want to work. So to the extent that the event is canceled, we are actually at a financial loss. It is a financial loss for us, and specifically depending on how close we are to the event. So again, there's two very important things with regard to your contract and keeping money. Number one, making sure that you identify the triggering event. When does the money go back and why, if the client cancels? Second part is why it is important that you're keeping the money. In other words, it's not like we're just saving the date. This is not just saving the date. We're saving the date and foregoing other business opportunities. We're, doing things behind the scenes that you don't even know about. We're hiring other personnel, this type of thing. So again, it's the nomenclature, the literal term that you use, whether it's deposit, retainer, payment, installment, that is not as important in most jurisdictions as how you define what happens to that money based on whatever parameters that you set. So a lot of times we get tripped up with these words retainer and deposit because in certain industries and in certain areas of the law, the word retainer and the word deposit are terms of art, meaning that if you use them in this circumstance, they have baggage with them. They bring with them a definition that everybody already agrees on. And that's going to be statutory and state specific. So I guess by way of example, with the word retainer is a term of art when it comes to the legal industry. So every state, whatever the oversight body is of the state of attorneys, like in Georgia, it's the state bar, which is overseen by the Georgia Supreme Court. And they have a particular definition of what a retainer is. And when a retainer is accepted, what are the mechanisms for when it can go back? So that there's no ifs, ands, or buts with a retainer for attorney services in Georgia, and likely in every state. On the other hand, we have deposit. Deposit is a term of art in landlord-tenant law or commercial property law. And that's going to be statutory in every state, meaning that the word deposit in a lease in California is, if you write deposit, that means something. You can write whatever you want after that, but it's very likely that a judge is going to go deposit. Okay, let's look at the statutes. Let's look at the common law. There is a definition that is subscribed to that. The issue here is that those uses, those terms of art, retainer and deposit, in those specific industries typically do not apply outside of those industries. So just because you might see that there is a court decision affecting how we interpret retainer, you have to look and see whether or not, okay, this is dealing with an attorney, or with deposit, this is in the landlord tenant or commercial real estate realm. These have specific meanings, so that way everybody's on the same page. With regard to the service industry, typically it's not so. And that's why I'm telling you that the important part is what follows the term that you use. So it's probably okay to use the word deposit. It's probably okay to use the word retainer. But the important part is what comes behind it. That is to say, the mechanisms for what happens to it if the event is canceled and why that is so. So those are the two important components, not necessarily what you call it. So I don't even want to say recommendation, but I have seen in my experience, I avoid either of those. And the reason why I do that is because in the event that, first, two reasons. Number one, in the event that you're having to go to court, which your contract should be written in such a way that you are in the upper hand and should avoid that at all costs. But if you find yourself in court, you're likely going to be in small claims court. Or if you're not in small claims court, you're going to be dealing with a trial judge. And the trial judge ain't got time for your mess. And in a hurry, the trial judge might not care that, retainer or deposit as a term of art doesn't apply to your situation, and they might take a layman's approach to it, and they might find the wrong way. So that's the first reason why, because I don't want to have to educate the trial judge that this is not a term of art. The second reason is because I don't want any baggage with the client. So I doubt that the client has had encounters with the word retainer. Most people have not. That is something that is typically within the legal realm. If a client has heard the word retainer, it's probably because they had to hire an attorney. And as a side note, again, even retainer as a term of art is different. I mean, I know it's state by state, but it's kind of like there are subcategories of the word retainer. So like retainers that from back in the day when you would give an attorney $1,000 and they would work at $10 an hour, but they would keep that, the $1,000 and you would never get it back unless you needed it, blah, blah, blah. But at any rate, okay. But the client has seen the word deposit. The client has seen the word deposit on leases, like apartment leases. And in the client's mind, and you got to think back before you were an event professional, when you saw the word deposit, you automatically, the baggage that comes with it is that it comes back to you. It comes back to you in a lease at the end of the lease, or it comes back to you if the lease is broken. In other words, deposit seems to be something that is coming back. And that might be their expectation. And it could be wrong according to the words of your contract, and it could be wrong in the terms of the law, and they would lose that argument in court. But you want to do the best you can to minimize confusion with the client. Even though you're in the right, you want to minimize the confusion. So avoiding deposit for that reason is probably a good idea. Avoiding the word retainer might be a good idea because, again, even though these two words in most jurisdictions and almost all jurisdictions don't matter to the wedding professional's contract, they still might have baggage that are brought in that a trial judge might mess up or the client might misunderstand. So that is my take on retainer and deposit. Using something other than that, but even if you do, it's okay. Just make sure everything is defined. And I want to take a second, though, to talk about, again, and I try not to mention COVID-19 in this episode, but I'll probably end up doing this. But typically, the money that we're talking about, whether it's retainer, deposit, installment payment, whatever you want, that is held on by the professional. These are in circumstances typically that are within the control of the client. We're not talking about force majeure. This is a completely different concept. If the event is going to be, it's going to be impossible to go forward with the event because of pandemic or whatever the reason is, that's something different than the client canceling because the client has cold feet, which would trigger your retainer or deposit language. With that being said, the law actually has a word for that action, that mechanism by which money stays in your pocket if the event is canceled. And that's called liquidated damages. I'm going to save a super long explanation of liquidated damages for another episode. But essentially what at the end of the day, what you're doing by having money that you keep that does not go back to the client for XYZ reason is you're saying, you and the client are saying to each other, we're not going to sue each other for breach of contract and go through that rigmarole. We are agreeing at the outset that if this deposit, retainer, whatever it is, clause is triggered, that's it. That is the extent of what I'm entitled to based on your quote unquote breach by canceling the event for the reason that's within your control. So it's essentially an agreement not to sue for money based on cancellation for XYZ reason, if that makes sense. You're avoiding the litigation concept by just agreeing at the outset that I'm good with the money that I have up until the point that, the event is canceled, or however you have structured your retainer deposit, in reality, liquidated damages clause. So that's how that works, the liquidated damages. It's a liquidated damages clause, liquidated being a finite amount and damages being the legal word for money. It's a finite or limited or set amount of money that you keep rather than going through and trying to prove damages at trial, blah, blah, blah. With that being said, depending on how your liquidated damages clause is set up, and I get this question quite often too, well, Rob, the client has canceled the event. I have a liquidated damages clause that says I get to keep X amount of money. Can I sue them for more? Can I sue them for full contract value? And depending on your jurisdiction, typically the liquidated damages clause and the law surrounding liquidated damages would say no. And the reason why you can't keep the money and then sue them for more is exactly what I was just talking about. The point of the liquidated damages clause is to avoid that litigation. You and the client are agreeing that the client won't be sued, and the client won't sue you for that money. You're agreeing that that money sets everything right. So the concept of keeping that money, the liquidated damages, but then suing them in order to get the rest of the lost profit, generally, the law will not support that, typically. So you have to be careful. That's why I'm saying, and again, this will be another episode, but structuring payments, not just the first payment, but structuring payments over the duration of the contract that are non-refundable. It's a process of accepting non-refundable payments as your liquidated damages structure. So I think, like Forrest Gump, that's all I got to say about that. Again, if you have ideas for content, please shoot me an email, rob@weddingindustrylaw.com. You can always shoot me a message on Instagram, leave a message on YouTube, smoke pattern, lights in the sky, however you choose to let me know what content you want me to cover. Happy to do it. And again, thank you to Trisha Bennett for providing the impetus for this episode. And like and subscribe to all the different places where you can get this podcast. And with that, I will see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.